Mr. Dorfner, how you doing today, sir?
Hi, George.
Spencer, how you doing?
Oh, good. My power shut off over the weekend, so my system's updating. I'm on my phone. I'm trying to get into my desktop. I may jump out of here right quick. We're working on it right now and try to get on my desktop.
Works for us. I think we've got the plaintiff's end well covered over here today.
All right. Well, good. Yeah, the judge did ask when I was in his court last time. He said, "Why are you here?" I said, "Well, Your Honor," I said, "I'm joined in this case. If it pleases the court, I'd like to appear." And so anyway, maybe it'll be good for me to come in case there's another hearing you want me to cover. And, he doesn't ask me those questions.
Well, he was going to let us do it remotely today, and I know Mr. Dorfner wanted to get this issue determined sooner rather than later. So
Yes. Well, you're so articulate, and I know you'll do a great job. I still am so downhearted that he didn't give us enlargement of time. But anyway.
Well, kudos to Mr. Dorfner on that.
We'd still like you, if you can, to appear to be here for the arguments.
Yeah, absolutely.
All right. I'm Gavin, by the way. You and I have not met.
Hi, Gavin. Spencer Dobbs.
Good to meet you, Spencer.
Gavin's the Yoda of the office.
Awesome. Good man to know. Okay, I'm trying to join in now on my desktop.
I'm trying to figure out my camera. Y'all see that big black line or whatever?
Yes, sir.
Yes, sir, Your Honor.
That's not attached to me. I'm not a cat, so whatever it is. What do you think it is? Oh, you know what? I know one. The camera. Okay. I got it. There's two cameras. So I wonder why it's using that camera. That's okay. This must be using the computer camera. Yeah, that's good. How's everybody this morning?
Good.
Judge, how are you?
Good.
Good morning, Judge.
How much rain everybody get? I got 3 inches. How much y'all get? You got 3? Aaron?
Yeah, we got 3 at the house.
How about out of town? Did you get any?
We did.
Zero.
I got some in my neighborhood. So much needed.
0 in central San Antonio, Judge. It was raining all around us, but not near my house.
Yeah, we have a place out in Harper up by Kerrville, and none there either, my wife said. So we got water in our house, so it was interesting. Okay, look, we went on recess before. This is cause number CV 57422. Kano versus Mata and Northern Natural Gas Company. Announcements first.
This is George Deutsch on behalf of plaintiff Michael Kano, and I'm joined today by Mr. McInnes, another Mr. Kano's attorneys, and then by Mr. Dobbs, who I believe you got to speak to last week on this matter, Your Honor.
Correct.
So it'll be the three of us here today, and we're ready to go.
Aaron Dorfner on behalf of Shane, Austin, Mata, and Northern Natural Gas defendants were present and ready.
Okay, and so the court having ruled already, everybody got the orders?
Yes,
Yes.
Your Honor.
And that leaves us with a continuation in effect of the defendant's motion to exclude the expert testimony of Frank Kawamura, and that is the court having ruled that there was not a procedural issue. And so now we're to the substance of his report that's being challenged. That is correct. Am I correct?
Thank you, Your Honor. You are correct.
Okay. And I read everything, including the notebook, including the responses, unless something was filed Friday, Saturday, Sunday that wouldn't be in here. May file anything else?
No, Your Honor.
Nothing else, Your Honor.
Okay, so I've read everything. I think I had not read the response before because it wasn't in the file, but I read it. So go ahead. We did a little bit on last week on the motion to exclude, but I stopped you from talking about the substance and having ruled the way that I ruled. This is where we are now. Go ahead.
Thank you, Your Honor. Just as a reminder, we're here on a pickup truck versus semi-truck collision. The defendant, Shane Austin Mata, was in a pickup truck and closed his eyes and dozed off and hit the rear side of a semi-truck sand hauler on 349 in South Midland County, right about the Upton County border. After the accident took place, the plaintiff was sent to a doctor in San Antonio by his attorneys to receive an experimental, unapproved, and ultimately unsuccessful treatment with injections of stem cells. As I recall from the last hearing, Dr. Kawamura was designated as a treating, non-retained expert, and that issue has been decided by the court. However, what remains is issues regarding the stem cell treatment, the science behind it, the reliability, the relevance of that opinion, and the qualifications to talk about that opinion, as well as the qualifications to talk about causation of the accident, that the accident actually caused an injury. So those issues are in front of the court today. We'll be asking the court to exclude on all of those bases. As the court knows, an expert needs to be qualified. Just being a doctor does not allow someone to testify about all aspects of medicine, all aspects of engineering, or anything like that. They have to be qualified on each one of their opinions. The plaintiff, the proponent of the expert, bears the burden of proof to come forward with sufficient evidence, argument, documents, information in order to satisfy Texas Rule of Evidence 702 and the familiar factors in Robinson and Dauber in order to be admitted. As the court knows, once an expert is admitted, they get instant credibility with the jury, so they can be prejudicial if their opinions are not grounded in solid science and they're not qualified, duly qualified to testify about the topics that they're testifying about. So to start out with the stem cell portion of it, Mr. Kano received a stem cell injection into his back to treat back pain. Stem cell injections are not approved by the Food and Drug Administration. They put out several warnings to the public about doctors that do stem cell injections and warn the public about them. I'd like to show the court what I'll ultimately ask to be admitted as exhibit number 7. Is the screen sharing working?
It's active. It's not up right now.
Okay.
There.
Is everyone able to see what I've marked at the top as Defendant's Exhibit 7 titled FDA Warns About Stem Cell Therapies?
I see it on a list, but not the individual document. I do see 7 FDA. Yes, it's just not open. I have 7 in the notebook.
I believe it's up now.
Yes.
Okay, and you've got the notebook. Mr. Dobbs has a notebook. I'm not sure if Mr. McGinnis or Mr. Deach does, but this is an article from the FDA warning about stem cell therapies. At this time, Your Honor, I'd like to move to admit exhibit number 7 to the record.
Response?
Mr. McKinnis, do you have any objections? You're muted.
Your Honor, as long as there's going to be no objections to us admitting the same type of FDA warnings as to epidural steroid injections, facet joint injections in the spine and those types of things, then we have no objection.
Richard Orfner, any response?
Yeah, I don't think I can pre-commit to allowing exhibits to be admitted without seeing them.
And Judge, I will represent to the court that the FDA warnings as to epidural steroid injections, which the court is well aware of in almost every case that you got spine injury, is on the same web page. I'll show the court that. So at this point, we don't object to this because it's really irrelevant.
I get no objection having been heard. Number 7 is admitted.
Thank you, Your Honor. I'll show you several portions. This comes from the FDA website. Obviously, the title is FDA Warns About Stem Cell Therapies. Here it says the FDA has the authority to regulate stem cell products in the United States. And important for this procedure and this hearing is what I've highlighted in green here that says you may be told that because these are your cells, the FDA does not need to review or approve treatment. That's not true, period. So we see in this article in exhibit number 7 that the FDA heavily regulates stem cell therapies and that most are not approved. There's another article that I would like to tender the court as exhibit 8, which comes from the FDA's website as well, titled Important Patient and Consumer Information About Regenerative Medicine Therapies. I'd like to move that's admitted at this time.
Okay, I have 8 in the notebook. Response?
No objection, Judge.
No objection having been heard. Number 8 is admitted.
Thank you, Your Honor. Court can have an opportunity to read that if it hasn't already, but this, I've highlighted a few important selections from the article. This is dated June 3rd, 2021, so just last year. Talks about these unapproved products, whether recovered from your own body or another person's body, include stem cells. The article goes on to say if you're being offered any of these products outside of a clinical trial for which the FDA has oversight, please contact the FDA. Gives contact information. I've also highlighted the portion that says from the FDA, please know that if you are being charged for these products or offered these products outside of a clinical trial, you are likely being deceived and offered a product illegally. Also important for this hearing is the FDA's warning that regenerative medicine therapies have not been approved for treatment of any orthopedic condition, such as, and give a list, including disc disease and back pain. goes on to state the FDA repeatedly notified manufacturers, clinics, and healthcare practitioners of the need for investigational new drug applications to legally administer these products and to ensure safety measures are in place prior to administration. I'll stop my share for a moment. So you can see by these articles and exhibits 7 and 8 that the FDA has put out warnings about stem cell therapies. Of course, this is concerning and problematic in the defendant's view for admission of expert testimony about injections of stem cells into Mr. Cano's back, for which he was charged approximately $50,000. I'd also like to turn the court's attention and share this screen with the court. This is a case from the 11th Circuit Court of Appeals decided in June of 2021. The gist of the case is the FDA sued U.S. Stem Cell Clinic LLC in Florida regarding its stem cell treatment. The clinic said that this procedure was legal, not subject to FDA regulation, and fell into exceptions within the FDA's regulation. The 11th Circuit Court of Appeals, after going through everything, found that the procedure did not fall within an exception and therefore enjoined the stem cell clinic from doing stem cell therapies. So just for the record, the citation is 998 Federal 3rd 1302, United States of America versus U.S. Stem Cell Clinic LLC. This goes to show the court, I think that's in the front pocket of the notebook I left last week.
It is, and I have read the case.
Thank you, Your Honor. This goes to show that the FDA is currently regulating, as of June of last year at least, and I'll represent to the court, but I've seen no updates or changes to any of these directives from the FDA or the case law. But the case goes to show that stem cell therapies are being regulated and scrutinized currently. And stem cell therapy, of course, is the component or the major component of Dr. Kuwamura's proposed testimony that the plaintiff has tendered to you. If you'd like me to move to the qualifications portion of it, I can, or if the court would like to hear a response to the stem cell portion, I'd be happy to allow that to go forward too.
Gentlemen, what's your choice?
Your Honor, if we may, why don't we address the stem cell issue? And then we can kind of go from there. And I'll address that issue on the medical side of it. And then Mr. Deutsch will address the legal and the law arguments, if that's all right with the court.
Sure.
All right, Your Honor. And so let me start off with the fact.
Hang on just a second. Court reporter problems. Hold on. What happened? You got it all. You got it all. She got all of it, but the computer shut off. Hang on. No, we're in recess. She got, it's all on the record. It's all right there. So.
Well, I have it on my printer machine, so just give me a moment.
All right, just a minute, guys. Just a minute. Could be the rain. Could be the rain. So, some of my children have never seen that much rain. Never seen rain.
I've never seen it.
Okay.
Okay, I got
Take your time.
what happened. Let me check my USB port.
Okay, we're going to be in recess for a minute, guys. Okay.
No
Sure.
problem.
Okay, back on the record in this cause. And we were at the point where Mr. McInnes was going to respond to the portion of the motion regarding the stem cell therapy.
Yes, Your Honor. And as I indicated, Mr. Deutsch will bring in the cases that talk about admissibility of stem cell treatments and things of that sort as well. But I think as a starting point, and I appreciate Mr. Dorfner's position that, look, the FDA has not approved it, but that does not set the standard of care that is applicable for a medical practitioner. The mere fact that the FDA has not approved it doesn't mean that it is not something that can and in fact is efficacious for the treatment of a patient and in the discretion and in the judgment of the physician. And just to give the court an idea of what I'm talking about there, and I'm not sure what exhibit number we need to make this. I believe Mr. Dorfner's last exhibit was number 7 or 8.
You have a list of what number we're on?
I do not.
Mr. Dorfner, do you remember?
Yeah, I've kind of jumped all over and used out of sequence numbers, but if you use start at 18, that won't overlap on anything that I've done for sure.
How about I just make it plaintiff's exhibit 1, Judge? Would that be all right?
Yeah, that would be better. Plaintiff's exhibit. What is
Okay, so I'm gonna, if I may I show the court, first of all, plaintiff's exhibit 1 so everybody can take a look at it?
Sure.
And this is an exhibit from the same FDA website that Mr. Dorfner's exhibit came from. And it's an exhibit dealing with epidural steroid injections. And the reason I believe this is relevant to this argument is, as the court is no doubt aware that, and I'm sure you have seen dozens upon dozens upon dozens of personal injury cases involving the spine where physicians are treating patients with epidural steroid injections or steroid injections generally into the spine. For example, Mr. Dorfner's own expert said that steroid injections in the spinal facet joints in this case were appropriate. And what's important about this is a safety announcement from the FDA. And the FDA specifically says injectable corticosteroids are commonly used to reduce swelling or inflammation. Injecting corticosteroids into the epidural space of the spine has been a widespread practice for many decades. However, the effectiveness and safety of the drugs for this use have not been established, and the FDA has not approved corticosteroids for such use. Further, and they actually require warnings be given to patients. The effectiveness and safety of injections of corticosteroids into the epidural space of the spine have not been established, and the FDA has not approved corticosteroids for this use. Again, additional information for healthcare providers. The effectiveness and safety of epidural administration of corticosteroids have not been established, and the FDA has not approved corticosteroids for this use. So what the purpose of this exhibit, Judge, is to demonstrate that the mere fact that the FDA has not approved use of a particular product, they don't approve products or they regulate the products, they don't regulate the procedures. But the fact that the FDA has not approved the use of the product does not mean that doctors don't use it and cannot use it. What really is at issue, and I believe the case that Mr. Dorfner cited relies upon the advertising that is done and the communication that is done to the patient themselves. In this case, just as doctors routinely use corticosteroids and the injection and treatment of pain in the back, Dr. Kuwamura and many other doctors for that matter, as Dr. Kuwamura explains in his declaration, which will mark as plaintiff's exhibit number 2, stem cells have been used to treat pain in the spine for over 20 years. And just as corticosteroids have been used to treat pain in the spine for decades upon decades. Yes, they have not been per se approved for this specific use, but trying to get the bureaucracy of the FDA to approve something sometimes does take decades upon decades upon decades. Does not change the efficacy of the treatment, nor does it change the fact that it is within the standard of care to use this type of treatment on patients. And as you'll see in Dr. Kuwamura's declaration, he discusses how long he's been doing this as an orthopedic surgeon, its use. The procedure itself, Judge, is one where while they are in the spine, and this is all done, the miter is done microscopically. They use a tube basically to get into the spine, and then everything is done microscopically. But what they do is they go and they harvest cells from the patient's hip. They go and pull actually bone marrow from the hip of the patient. These are the types of red blood producing cells that are, by the way, approved by FDA for use in procedures. And they improve the development and of healing cells. And that process is what is used by Dr. Kuwamura and many other physicians in treating the spine. That is the stem cell regenerative procedure. Now, a lot of doctors are out there, fly-by-night operations where they're saying, well, we're pulling stem cells from, these other locations, and we're going to fix all these crazy conditions. Well, that's not what Dr. Kuwamura is doing. It's very clear from his affidavit or his declaration. It's very clear from the literature that's out there. This is an efficacious procedure medically. It's not one that is outside the standard of care. I don't believe that Mr. Dorfner is going to find someone that can tell you it's outside the standard of care. It certainly was not included in his motion. Dr. Kuwamura, however, does talk about it in his declaration, which the court, because this is a Daubert challenge, has every right to review and rely upon. And so that's the medical side of it. And Judge, at this time, we ask that exhibits 1 and 2, which are 2 is attached to our response, and that's Dr. Kuwamura's declaration, be admitted.
Response.
Thank you, Your Honor. Dr. Kuwamura's statement is not a declaration under the rules. It's not an affidavit that's notarized. Dr. Kuwamura is not here testifying today. The court has been deprived of any of its gatekeeper functions to question Dr. Kuwamura about the things Mr. McGinnis has represented, which are not evidence, such as a lot of doctors are doing it and it's just okay. So I would point that out to the court, but it is within the court's discretion to consider anything that it would like during a Daubert hearing.
And Your Honor, to be clear, just in due respect to Mr. Dorfner, the Texas legislature passed a statute in Civil Practices and Remedies Code. The section, title, and provision of that statute is cited at the top of Dr. Kuwamura's declaration. Mr. Deutsch can give you the citation. Regretfully, I don't have that popped up here, but Texas specifically states that an unsworn declaration in the format used by Dr. Kuwamura is admissible even if as an affidavit in the state of Texas. It's admitted by the Civil Practice and Remedies Court. And George, if you could show the court that section, I would appreciate it.
Absolutely. If you'll allow me to share my screen, I'll bring it up right now for the court. Let me do this here. So this is Exhibit A to plaintiff's motion. It's Exhibit 2 for the purposes of today. Pursuant to Texas Civil Practice and Remedies Code 132.001, a declaration that is made under penalty of perjury has the same legal effect as an affidavit for all purposes in the state of Texas, and the court can read that 132.001 of the Civil Practice and Remedies Code. And there's specific language that that section uses, and Dr. Kuwamura's declaration uses all that language. And if you go down here to the very bottom, it says, "I declare under penalty of perjury that the foregoing is true and correct." It's signed by the declarant. This is 100% legit under the Civil Practice and Remedies Code. So back to Mr. McInnes.
Your Honor, and that's it for the that. And as I think Mr. Dorfner recognizes, because this is Daubert hearing. The court's not bound by the rules of evidence as it is anyway. But this particular declaration clearly meets the requirements of Chapter 132 of the Texas Civil Practice and Remedies Code.
The 1 and 2 are admitted.
Okay.
Plaintiffs 1, plaintiffs 2 are admitted. Now, we need to make sure we get copies to the court reporter. I have notebook copies of some. Well, no, I don't have notebook. We just need to make sure those exhibits are emailed to Ms. Verdoza. I'm sorry, to Monica M. Lancaster, or you want to you? Okay, to a record at mcounty.com. All little letters, right? A record at M. That's a great name for a court reporter, for the record. A record at mcounty.com. Okay, go ahead.
In terms of the law side of it, and I will let Mr. Deutsch take over from there, because he's got, our response has a number of cases where this type of evidence was indeed admitted. And so I'd like Mr. Deutsch to share that with the court.
Sure. And Your Honor, my understanding is we're just talking about the stem cell issue right now. Is that correct?
That's my understanding.
Okay. Well, Dr. Kuwamura determined that Mr. Kano needed these stem cell injections based on what's called a differential diagnosis. A differential diagnosis is a reliable methodology, according to the Texas Supreme Court, and it involves treating a patient, examining him, taking a medical history from him, looking at his MRIs and any diagnostic imaging, and then ruling out or ruling in potential causes of these symptoms and conditions until you reach a conclusion and a diagnosis. And so as a part of that, he reached the conclusion, the expert conclusion, that Mr. Kano required stem cell injections to address his facet joint pain and his disc herniations at L4, L5, and L5S1. And I think the most important case that bears stating and talking about today is this case, Oni versus Christ. Oni versus Christ, and that is out of the Tyler Court of Appeals. And in that case, the Tyler Court of Appeals rejects every argument that the defendants are making in the instant case about stem cell injections. The court found that stem cell treatment is commonly used for back and sports injuries. It found that it is not experimental and is based on multi-year research. It found that this notion that it was not fully FDA approved is immaterial. And I want to share my screen just briefly and show you one particular line from this Oni v. Chris case. And the legal citation is 517 Southwest 3rd, 882. And it says, here, the record contains evidence indicating that these stem cell injections have been independently tested, peer-reviewed, and accepted within the relevant medical community. And that is, of course, exactly what plaintiffs are saying in this case, that they're independently tested, peer-reviewed, and accepted, and certainly do meet the standard of care under the law here in Texas. Now, what that court said, what the Tyler Court of Appeals said in Oni versus Chris, is in direct line and alignment with Dr. Kuwamura's declaration, which has already been admitted by the court. And that says that Dr. Kuwamura has performed these stem cell injections for 20 years. That's 2 decades. And that they've been around and being performed by others for 40 years. That's 4 decades. And that the versions of the procedure are currently being considered for FDA approval. So the one thing that seems to bother defense counsel the most is something that is currently being considered for approval now. And I think we would be remiss to talk about this without talking about the report of defendants expert, Dr. Mofoletto, who says, these stem cell injections may very well prove necessary for Mr. Kano. So on the one hand, you have plaintiff's doctor, Dr. Kuwamura saying, hey, Mr. Kano needed stem cell injections. On the other hand, you have defendant's doctor saying, Mr. Kano may very well need stem cell injections. You have the Tyler Court of Appeals saying, hey, these are tested, these are legit. And so everything out there is in lockstep regarding the admissibility and efficacy of stem cell injections. So for those reasons and several others that we'll get into here later, we believe defendant's motion should be denied.
Okay. You want to respond to the
Yes, Your Honor.
stem cell before we go to overall qualifications?
Ultimately, the court, as the gatekeeper of its evidence, needs to decide whether or not it wants an expert testifying to the jury about something that's being warned about by the FDA. The FDA approval or the FDA's comments about epidural steroid injections that Mr. McGinnis showed you is not the same as a stem cell injection. As you can read in the FDA warnings in the literature in the cases, stem cells are biological products that are harvested from people. It's not the same as a steroid medication being injected to the back. So we would argue that that reference is irrelevant and should not sway the court. The case that I cited from the 11th Circuit Court of Appeals, Mr. McGinnis said it had to do with advertising. That's not true. The body of the case talks about the procedure and how the procedure is in fact regulated by the FDA based on the things that they do with the stem cells. Here, notably, there's no evidence of what was done with the stem cells other than that they were processed, which would make them fall into regulation with the FDA. There's no testimony, although there's argument from the court. There's no testimony from Dr. Kuwamura himself. There are no FDA articles. There are no learned treatises saying that stem cells are approved for injections the way that Dr. Kuwamura did them. I'll remind the court that the plaintiff has the burden of proof to come forward with that. There's no evidence that what he did was okay, other than he said he did it and then it's okay. That's a classic ipsa dixit that the Texas Supreme Court has warned about. Ipsa dixit translates roughly to, because I said so, it's okay. That doesn't meet the Robinson standard. That doesn't meet 702. That doesn't meet the standards for admissibility. Now, they talked about my expert opinion, which I'd like to share with the court because it's been misrepresented of what it is. This is my expert opinion, which I've marked as Exhibit 6, and I'd like to admit for the record as Exhibit 6.
No objection, Judge.
No objection.
No objection, Judge. And again, this is a Daubert challenge, so there's no issue with it.
Exhibit 6. The defendant's Exhibit 6 is admitted.
So this is Exhibit 6 is a report from defendant's orthopedic, board certified orthopedics expert, Dr. Muffaletto. Dr. Muffaletto in the highlighted portion says stem cell injections are still in the experimental stage and have an unproven track record in successfully treating painful spine conditions, whether degenerative or traumatic. The FDA currently does not approve of stem cell injections into discs or facet joints. In addition, there appears to be no compelling indication to inject this disc pain generator. And it goes on to talk about that. So the logical next step, according to Dr. Muffaletto, that wasn't completed was an RFA procedure. So my expert did not say stem cells were okay. In fact, he cited the FDA warnings that I showed the court, as well as 2 medical journals that talk about the experimental nature and the unproven nature of stem cells. I'd like to briefly touch on the Oni case that was put forward for the court and the proposition that because the Tyler Court of Appeals in 2017 commented on stem cells, then they should be automatically admitted in this case. The court knows that that's not the case. For example, if an expert came in and said, well, antibiotics can treat headaches, but they really couldn't, just because the fact that antibiotics are a accepted form of treatment doesn't mean it's accepted in the specific case for the specific application, the way it was done, how it was administered. And we just have no evidence of that other than the statement from Dr. Kuwamura. Dr. Kuwamura's statement is incredibly conclusory and even concludes that the FDA is considering approval of this. That should be what the court needs. It's not even an approved method, and Dr. Kuwamura says it in his statement. So where's the evidence in this case that stem cell injections, maybe they were appropriate. Maybe the FDA got it wrong. Maybe the FDA shouldn't have warned patients about getting stem cells. Maybe the FDA shouldn't have warned that if people are being charged for them, it's illegal. Maybe that's all wrong. Maybe just assume stem cells are the appropriate treatment. There still needs to be evidence that the stem cells were indicated in this case, properly administered, and go through all of the Robinson factors in order to qualify that expert opinion. As the court knows, the Robinson factors are very detailed. The Texas Supreme Court says to trial courts such as yourself, you need a rigorous examination of each of these things, the extent to which the theory's been tested, the extent to which the technique relies on subjective interpretation, whether the theory has been subjected to peer review or publication. Where's the peer review and publication that says stem cells are okay? The technique's potential rate of error, where is that? Whether the underlying theory or technique has been generally accepted and is valid in the relevant scientific community. Well, the evidence you have before you is Dr. Kuwamura saying, oh, of course it is, I've been doing it. That superimposed on the FDA warning saying, don't get this without making sure it's approved. And then the non-judicial uses which may have been made for the theory or technique. They have not satisfied the Robinson factors. They have not satisfied the factors in Rule 702. This is going to be highly prejudicial testimony if it comes into court and we have a doctor up there telling a jury of lay people, oh yeah, stem cells really are legitimate. One more point about the Oni case from the Tyler Court of Appeals in 2017. It was decided in 2017. I've tendered the court a case when the FDA is enforcing and prohibiting stem cell clinics in 2021 from doing what appears to be the same type of procedure here. While Dr. Kuwamura took stem cells from the hip and the stem cell case from Florida was from fat, both of the stem cells were processed and the FDA moved to enjoin that stem cell procedure. And the evidence before us in Dr. Kuwamura's operative report shows that the stem cells were processed again in this case. So again, I would say to the court, the question really is, as a gatekeeper, does the court want to allow an expert to come in and testify about something that's highly questionable without the ability to talk to the expert, without the ability to see the specific science behind it, and without the satisfaction of all of the Robinson factors?
Your Honor, if I may inject one thing.
Couple of questions before we go on to the issue of the overall qualifications, because that's the next issue. So basically, we're doing under the Series 700 rules. We're doing this now when we would normally do it with the doctor here or present as a witness. So what do you say, plaintiff's lawyers, about the fact that Mr. Dorfler is not able to examine him for this hearing today? And is it going to be more effective for me to hear your arguments and then carry my ruling until when the doctor can be examined? I don't think Mr. Dorfler is going to lose his ability to ask the doctor questions in the 702 hearing just because we're doing it today. I think that has to happen.
Your Honor, I think you've actually hit the nail on the head. And Dr. Kuwamura will be coming. We will pay for him to attend and come and testify live at trial. And so Mr. Dorfler will have plenty of opportunity to cross-examine him at that point in time and re-raise this issue. But
I think he has the opportunity. I don't think he's lost the opportunity to raise these issues outside the presence of the jury as the gatekeeper role, because that's normally the way that it happens.
You're absolutely right, Judge. And I think this would be better placed to have this hearing at the time. We've submitted the court with sufficient evidence to overcome his objection at this point in time. But he can re-raise the issue, and we won't object to him cross-examining Dr. Kuwamura outside the presence of the jury on his qualifications and all the issues that he's raised in his motion. We certainly won't object to that because he has the right to do that.
Mr. Dorfler, you see what I'm saying? That we're doing this now, and this is all well presented by both sides, including last week. But are you waiving your rights? You want me to rule without you having the opportunity to cross-examine the doctor, somehow cross-examine him in the setting of an out of a jury, a hearing outside the presence of the jury?
I learned a long time ago, you should never waive your rights. So I don't want to waive any rights. I understand what the court is saying. I certainly think that the opportunity should be taken early. That streamlines the trial preparation process. It's efficient for the jury not to have to wait around for such a hearing. But I don't want to waive my opportunity to cross-examine Dr. Kuwamura.
Yeah, that's just part of the jury's, that's just part of the job the jury has to accept, that sometimes way too much happens outside the presence from my perspective. But on this, I believe that if I rule today, it would be premature because he hasn't been tested. I mean, I have a gut what I'm going to do, but that's not good enough. So why don't we go ahead and if the stem cell, again, it's well covered in everyone's responses and motions and responses. And I think I've pretty much heard enough about that and read everything. So why don't we go to the overall qualifications? And again, recess the hearing until Mr. Dorfman has an opportunity to challenge him by cross-examination, because I think that anything else is premature.
Your Honor, may I suggest, I mean, I certainly don't have a problem with us going through this exercise, but I think perhaps the court's got the pleadings, the motions, the response. I'll submit our two exhibits. I'd like to suggest for the court, just for a matter of judicial economy, that perhaps we go ahead and defer the court's ruling until after Dr. Kuwamura is taken on voir dire at the trial. And that way we don't take up the court's time for the rest of the day. I mean, I don't mind going through the argument because I love arguments. And I think Mr. Deutsch has got a great argument for the court. But if we're going to be readdressing this issue, could we perhaps defer the rest of this hearing until that time?
Mr. Dorfman, you want to go ahead and?
I don't have any objection to that.
So what we'll do is we'll stand down and we will continue the hearing because I didn't change this, as you know, I didn't change the scheduling orders. I denied the motions on the depositions, and so this is really the only thing. Why don't we stand down and then sounds like qualifications and things like that is more simple, I think, for me, I think. But at least Mr. Dorfman will be able to cross-examine, because to be honest with you, I've never ruled without, I mean, I've only been judged for 4 years, but even as a lawyer, I never asked for a ruling or objected to a ruling. And as a judge, I've never ruled until the in-person or Zoom hearings were held under the Series 700.
Thank you, Judge. We appreciate that. I think that's the way to go.
Yeah, and that way we do it as a pretrial. I mean, we don't have to. I mean, the way I read it, I don't think you have to call him and proffer him, and then I think we can do it as a pretrial on the day of the trial, on whatever day he testifies.
Right, Judge. We could do that. We're allowed to do that under the rules.
And everybody could be prepared, whichever direction the court would go. You have to anticipate that, but you have to be prepared on both directions.
Thank you, Your Honor.
Mr. Dobbs, what do you think? I'll cut you off.
Judge, I think it's efficient use of the court's time, and I certainly agree.
I'm glad we did this today, because it's a different animal than qualifications, and it's a different animal than threshold. Is he even an expert in this case, which has been decided to the detriment of one side and to the benefit of the other. But if that's the kind of the unanimous thought process of how we should do it, because I think that Mr. Dorfman is correct not to waive, because I don't think anybody should ever waive the right to question an expert when it comes to these threshold gatekeeper roles. but I don't think the gatekeeper threshold role when it comes to the individual topic of stem cell use and efficacy and all of that, as well as overall qualifications. I just don't think it should ever be done without full vetting of the I almost said victim, full vetting of the doctor.
I can tell you, Judge, that these doctors, especially the treating doctors, do feel like victims in these types of cases because they get put through so much just for taking care of a patient.
Right. That's part of that's just part of it for the role they play in our judicial system. So.
Yep. Thank you,
Okay.
Judge.
Without objection, we will stand down and we will recess until we have the final part of the hearing on expert qualifications and expert treatment, and we'll do that on the day of the trial.
Thank you, Judge.
At some point during before or at some point during the trial outside the presence of the jury.
And I would suggest, Judge, if it's okay with the court, so frankly, I don't want to have to pay Dr. Kuamura twice for having to come down to the court. So if we could just do it when he comes in for trial and just take a recess from the jury at that point in time, I think that would be more efficient for everybody.
And I think that's normally what we do. That's normally what we do in this court.
Yes, Your Honor.
And of course, that means you got to pay him, as you know, you got to, whatever that price was that I heard last time, you all will have to pay that due, I guess.
We will. That's one of the pains of trying to take them away from their practice. You know, they got a lot of patients they would prefer to be treating than dealing with all of us. And so, but that's the nature of our system, regretfully.
Okay. Well, if there's not anything further, we'll stand in recess and then, but I appreciate the efforts and I did read everything. So exhibits.
Exhibits, plaintiffs 1 and 2, and defense 6, 7, and 8. If they could email them to
Plaintiffs 1 and 2 and defendants 6, 7, and 8. That's what was brought before the court and admitted today. And so a record, RECORD, a record at M as in Midland, mcounty.com.
Is it mcounty.com?
At M as in Mary, mcounty.com.
Got it. Thank you, Judge. I'm a little deaf as I'm getting older, so I heard M. I wasn't sure if I heard county or not, but now I got it right.
mcounty.com, and that way we'll have it all. The other ones are already admitted with Ms. Lancaster, and she has them since we were live. But anyway, hope Zoom helped you folks out, and we will see you in person next time.
Thank you, Judge. Look forward to seeing you in person.
Okay, thank you all very much.
Thank you, Judge.
May we be excused.
Yes, thank you all. Have a
Thank
good
you.
day.